India Legal presents Quartz Roundup.
The Supreme Court has issued notice on a batch of petitions challenging the election of External Affairs Minister S Jaishankar to Rajya Sabha from Gujarat. The pleas have also raised the issue of Election Commission's power on issuance of separate notification for holding by-polls for casual and regular vacancies in Rajya Sabha. One of the petitions against Jaishankar has been filed by Congress leader Gaurav Pandya. The Supreme Court has sought the response of External Affairs Minister Dr. S Jaishankar in a plea challenging his election to the Rajya Sabha from the state of Gujarat. A three-judge bench comprising Chief Justice of India S A Bobde and Justices A S Bopanna and V Ramasubramanian issued notice to Jaishankar and asked him to file his reply by 8th of December. The petition filed by Congress leader Gaurav Pandya has assailed Jaishankar's election, claiming that the Election Commission issuing separate notification for holding by-polls for casual and regular vacancies in Rajya Sabha was in violation of the law. Earlier, the top court has said that it would like to give an authoritative pronouncement on the issue of EC's power on issuance of separate notification for holding by-polls for regular and casual elections to fill vacancies in Rajya Sabha. The pleas pertain to 2019 Rajya Sabha by-poll on 2 seats from Gujarat, and both seats were won by BJP candidates. Jaishankar was elected to Rajya Sabha on 5th of July last year in by-polls held on seats vacated by Union Minister Amit Shah and Smriti Irani. Jaishankar had defeated Congress candidate Pandya in the by-polls. The Congress leader had moved the High Court, challenging the election on the grounds that the Election Commission's notification treating the 2 vacant seats to be of different categories and requiring by-polls to be held separately were illegal and in violation of provisions of the Constitution, the Representation of People RP Act 1951 and the Conduct of Election Rule 1961. The Gujarat High Court had in September 2019 dismissed Pandya's plea. Pandya, in his appeal before the Supreme Court, has stated that the High Court erred in law by ruling that the election petition filed by Pandya was to be dismissed on the line of the ground that he was neither a voter nor a candidate in the election in question. It is Pandya's case that in order to fill up the vacancies so created, the EC was required to notify the vacancies under Section 147 of the Representation of People Act 1951, calling upon the elected member of the Legislative Assembly of the state of Gujarat to elect a person for filling up the vacancies. But only a single notification notifying such casual vacancies and calling upon the Legislative Assembly of the state to elect alternate candidates ought to have been issued by the EC. Pandya has contended that by following the process of dual election, the 2 vacant seats were usurped by the BJP. But if single election were held, then Congress could have won at least one of the seats. We will give you short date and it will be listed on non-miscellaneous day, the court said at the hearing, which was conducted via video conference. Bureau Report. The Supreme Court is hearing petition challenging the Reserve Bank of India's move to charge interest on term loans during the moratorium period introduced in light of the COVID-19 pandemic. The bench of Justices Ashok Bhushan, R. Subhash Reddy and M. R. Shah is hearing the matter. The centre urged a bench to not intervene and provide further relief to borrowers under Article 32, as the government was already on top of it. Solicitor General Tushar Mehta told top court that many relief packages and schemes have been worked out with technical experts and the intervention of the court in fiscal policy. Issues was uncalled for. The law officer informed court that the government was not oblivious to the stress suffered by various stakeholders, but there was no room to do anything beyond the constraint of finance. Senior advocate Abhishek Manu Singhvi appeared for the Power Producer Association and told court that extraordinary situation demanded intervention under Article 32, and though he did not press for liquidity injection or specific fiscal reliefs for the power producer sector. In this background, the top court asked the Power Producer Association to put forth suggestions to the RBI and sought the RBI's response. The bench disposed of the pleas wherein the petitioner was satisfied with the compound interest waiver. The hearing in the rest of the matter will continue next week. A three-judge bench of Justices Ashok Bhushan, R. Subhash Reddy and M.R. Shah of the Supreme Court has allowed the demolition of 4 illegal religious structures on public land in Haridwar. The demolition deadline, however, has been extended to May 31, 2021. Acting on a plea by state government, a three-judge bench declined to entertain intervention application by Akhil Bharatiya Akhada Parishad against the proposed demolition of the illegal structure. The state of Uttarakhand has contended in court that the land belongs to the irrigation department. The court said that it cannot accept the contention that the structure cannot be demolished as they have been classified as unauthorized structures. Justice Bhushan said that these structures are unauthorized as these were constructed without permission. The state had maintained that it would take time to clear all illegal structure in Haridwar, as many of them are used to host Kumbh Mela scheduled early next year. The High Court had taken suo motu cognizance of the issue as the state government had failed to comply with the 2009 order of the Apex Court, which directed the state government to remove these structures. The Supreme Court has set aside a bail granted by Allahabad High Court to a rape accused. We are disturbed to notice the manner in which the High Court has casually released the accused on bail despite having noted that he was involved in other serious offences and had committed offence even while on bail. The bench comprising Justice A.M. Khanwilkar, B.R. Gavai and Rishikesh Roy said while directing that the accused shall remain in jail in connection with another crime registered during the pendency of the trial of this case. Rizwan was charged under Section 376 of Indian Penal Code and Section 3 and 4 of the Prevention of Children from Sexual Offences Act. Before the High Court, the accused had contended that the victim is aged about 17 to 18 years and she was having relationship with him on the false promises by him to marry with her. It was further contended that the victim understand the future and pre-marriage sex even after knowing its result. She was in consensual relationship from the last 1 year with her fiancé. Without expressing any opinion on the merit of the case, the High Court had found it to a fit case for bail. Following this order, he was released on bail but again got arrested in connection with some other offence. It is reported that accused was released on bail after the High Court order but came to be arrested in connection with some other offence. That makes no difference. In our opinion, the impugned judgment cannot stand the test of judicial scrutiny, the bench observed while allowing the appeal filed by the victim. The Supreme Court has held that a High Court cannot dismiss a revision plea on the ground that the appellant's counsel was not present, noting that an amicus curiae should have been appointed in such a case. The bench of Justice D.Y. Chandrachud, Indu Malhotra and Indra Banerjee passed an order to this effect while hearing a plea filed by a daily wager who was convicted under Section 25 of the Arms Act by a judicial magistrate first class back in 2015. The appellant's conviction was upheld by the additional district and session judge in 2017. Thereafter, he approached the Punjab and Haryana High Court through a revision petition filed by the Legal Service Authority, Rohtak. The High Court, by its order dated February 11 this year, dismissed the revision for want of the presence of the appellant and his advocate. This prompted the appellant to approach the Supreme Court before the Apex Court. The appellants argue that he was a poor daily wager and had been falsely implicated in the present FIR. It was submitted that because of the insufficient means source of income, he requested the jail authorities for legal aid in filing the criminal revision before the High Court. Coming to the aid of the appellant, the Apex Court held that instead of dismissing the revision for absence of the counsel, the High Court should have appointed an amicus. The court thus set aside the order of the High Court and ordered that the revision petition be restored to the file of the High Court. It also directed that the appellant be let out on the bail, as he was granted bail during the pendency of the earlier proceedings. The Supreme Court has permitted a death row convict to attend the last rites and ceremonies of his deceased mother under police escort. Vikram Singh, alias Vicky Walia, and Jasveer Singh were convicted and sentenced to death for the offence of kidnapping Abhi Verma, alias Harry, a school student, in Hoshiarpur and killing him with an anesthesia overdose in 2005. The Supreme Court had confirmed their death sentences by dismissing their appeals in 2010, and the review petition filed by them were dismissed in 2017 after the mercy petition preferred by them got rejected. They approached the Rajasthan High Court. They said writ petition was dismissed by the High Court, judgment was upheld by the division bench, and thus he approached the Apex Court by filing an SLP. Before the Apex Court, it was submitted that the mother of the Vikram Singh died on 13th November 2020, and some of the last rites, including Bhog ceremony, are to be performed at Patiala, and thus he be permitted to attend these ceremonies. In this regard, the State Council submitted that there is no provision that a death convict can be released on a parole. However, he suggested that he can be afforded the permission to attend the last rites and ceremonies of his deceased mother, provided he is accompanied by the police escort all the time. The bench, comprising Justice Uday Umesh Lalit, Vineet Saran and S Ravindra Bhatt, accepted this suggestion and issued the directives. And now we have Advocate Shivam Sharma with us. Tell us about the court's proceeding in this matter.
Yes, in this case, the court permitted the Vicky Walia to allow to attend the last rites and ceremonies of his deceased mother on 19/11/2020 and 21/11/2020 in police escort. Vicky Walia was convicted and sentenced to death for the offence of kidnapping Abhi Verma, alias Harry, and killing the school student. His appeal has been dismissed earlier by the High Court. The court in its order also stated that the specialty shall be available only from 10 a.m. to 4 p.m. on the relevant days and for same address. All possible case shall be taken by the police escort. The court order in the conclusion. Yes.
Thank you so much, Shivam, for the complete. Delhi High Court has issued notice in the PIL seeking the recognition of same-sex marriages under the Hindu Marriage Act. The PIL has been clubbed with an allied petition seeking that the Special Marriage Act and the Foreign Marriage Act be interpreted to also apply to the marriages of same-sex couple. Therefore, the court decided to hear both matters together. While posting both matter to be heard together, the court also directed that the counter affidavit in the instant case be filed within 4 weeks and that the rejoinder there to be filed within 4 weeks thereafter. Appearing for the petitioner's advocate, Raghav Awasthi submitted that the language used in the Hindu Marriage Act is gender neutral. However, the same would apply to the same-sex marriages as well, he submitted. Similar submissions were made with respect to the Foreign Marriage Act as well, that it does not distinguish between heterosexual and homosexual couple. The PIL concerning the recognition of same-sex marriage under the Hindu Marriage Act was earlier before the bench of Chief Justice D.N. Patel and Justice Pratik Jalan. In the last hearing, the court had directed the petitioner to compile list of those personally aggrieved by the non-registration of same-sex marriages orally. Observing Solicitor General Tushar Mehta had submitted that the Indian legal system and values do not recognize marriage which is sacramental between same-sex couple. The Delhi High Court has been informed by the Delhi government today that wearing mask while driving is compulsory, and that order has been passed in April and remain in the force. A single judge bench comprising Justice Naveen Chawla, while hearing the plea through video conferencing, clarified that no more time will be granted on the next date of the hearing. The petition has been filed by Advocate Saurabh Sharma challenging a 500 rupees challan issued to him by Delhi police for not wearing a mask while driving alone. Advocate Joby P. Verghese, appearing for the petitioner, submitted that after the April 4 order, the Delhi Disaster Management Authority, a press conference was organized by the Union Health Minister in which it was told the people driving alone in the car are not required to wear a mask. The plea stated that the officer issuing the challan failed to provide any executive order that makes it mandatory for a person travelling alone in a private vehicle to wear a mask. The bench had allowed 2 weeks' time to the ministry to put up the correct position before the court and has listed the matter for hearing on 7th of January. The Karnataka High Court has directed the state government and Bruhat Bengaluru Mahanagarpalika or BPMP to come up with a scheme for identification of homeless and destitute children in the city. The court passed this direction while hearing a plea seeking the prohibition of children from selling product at traffic junctions in Bengaluru. While passing the said direction, the division bench of Chief Justice Abhay Srinivas Oka and Justice Vishwajit Shetty observed this is a serious issue as children are forced to do begging or sell things. They are deprived of their fundamental right guaranteed under Article 21A. If their circumstances are forcing them to do so, then it is a violation of their fundamental right guaranteed under Article 21. Pertinently, the bench clarified that before the commencement of the exercise, the scheme for identification will have to be submitted to the court. The court added that BPMP could always approach non-governmental organizations, NGOs that work in the field for help in compilation of data on children involved in beggary, selling items at traffic junction. It was further stated that subsequent to the submission of the scheme, the bench would issue direction for implementation of the provisions of the Juvenile Justice Act, specifically Chapter 6 of Act. Further, the court asked the state on what steps it would have taken after a scheme was in place. These observations were made by the court in a plea moved by NGO Let's Get Foundation seeking a direction to prevent the deployment of young children to sell product at traffic junctions in the city. In order to avoid ambiguities about the application of anti-defection law, the Kerala High Court has directed the Election Commission to obtain a written declaration from the candidate about the support from a coalition. The petitioner K. Shivadasan had won election to Koduvally municipality as an independent candidate with the support of the United Democratic Front coalition of the municipality. However, the Congress party, a constituent of the UDF coalition, has fielded another candidate against Shivadasan. After winning the election, the Shivadasan submitted a declaration that he was an independent member of the UDF. Following this, a rival political member filed a disqualification petition against Shivadasan, alleging that Shivadasan incurred disqualification by joining a coalition after contesting the election as an independent. The disqualification petition relied on Section 31C of Kerala Local Authority Prohibition of Defection Act 1999, which says that if an independent member not belonging to any coalition joins a coalition after being elected, it amounts to defection. The Election Commission observed that Shivadasan could not be regarded as a UDF candidate when there was another candidate fielded by the Congress party. The court noted that there is no provision prescribed by the Election Commission or under the statute to record the arrangements made among political party or independents for the purpose of contesting an election under the umbrella of coalition. Well, that's all in Court's Roundup. Thank you for tuning. Keep watching APN.
India Legal presents Court's Roundup.